All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable F. Rand Wallace, Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session with the 5th District Court of Appeal, and we have the pleasure of being here this morning at the Jacksonville University College of Law. First, I want to thank Dean Allard for hosting us here, and I also want to introduce the other members of the panel. To my right, Judge Adrian Sal from Duval County, and to my left, Judge Paige Kildane, also from Duval County. And first off, housekeeping matters. If anybody has a device that may unexpectedly make a sound, please place them on mute or turn them off, better yet. I have done that because it's really embarrassing when the person laying down the ground rules has it happen to their phone. So that's happened before, not today. So we have 3 cases on the docket, and after the cases are finished, I'm going to ask if the lawyers could probably interact a little bit with the audience, which are students from JU, a lot of students from JU. So right now they're probably, if they're 1Ls, they're sick to their stomach waiting to see when their first exams take place, so maybe you can put them at ease over that. But just a little bit of your background and a few questions, but we want to keep things moving along because we have 3 cases. Also, I'm going to assume for purposes of rebuttal that you would like 5 minutes unless the appellant, unless you tell me otherwise. The first case that is on the docket is David Scott Wells et al. Versus Rodrigo Quintero et al. And with that, I will let the parties proceed. Is Ms. Stein?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court. Dinah Stein on behalf of the petitioners and appellants, Dr. Wells and North Florida OBGYN. We appreciate the 5 minutes of rebuttal. And we are here today, of course, seeking review from this court of the trial court's order declining a motion to dismiss medical malpractice claims, which I believe by all accounts are undisputedly uncorroborated. Now, the reason we asked this court for alternative jurisdiction, and I'll start with that, is because it's not entirely clear from the court's order exactly why she declined on the second time around to dismiss the claims that are uncorroborated. The first time she did. I think, looking now at this record, I might be in somewhat agreement with plaintiff to the extent that it looks to me like she agreed with us that the expert, Dr. Del Carmen, was not qualified because otherwise it just doesn't make sense that she dismissed the claims at issue the first time around. And on the second time around with the amended complaint, it appears that she may have agreed with plaintiff that you don't have to corroborate every claim. So we have either way, either remedy gets us to where we need to be, which is review of a clean legal issue. We are not asking this court to reweigh evidence unless, of course, she did find that the expert was qualified, which is clearly improper. But other than that, we'd like a ruling, and that's the legal issue, and a very interesting legal issue that we're disagreeing on. And that is, does a 30-year-old case from this court and the holding in that case dictate what happens here, or do the statutes, chapter 766 as they exist today and as 3 other appellate courts have found, do those control and make dismissal mandatory? Now, I'm going to go to the plaintiff's argument, and that is section 766-203 hasn't changed in 30 years. And so we have this case from this court long time ago where the court laid down a rule of law, which we don't take any issue with, and that is a plaintiff does not have to identify every theory of negligence in pre-suit in order to be able to bring that to litigation. And so what that means here, for instance, if Dr. Del Carmen said in pre-suit that Dr. Wells didn't use a proper containment bag when he did the morcellation, that doesn't stop the plaintiff from bringing other counts against Dr. Wells because they've now gotten past the threshold of showing he was medically negligent, at least for purposes of having a cause of action.
But your view is that would not extend to other employees, other specialties within the operation, correct?
Yes, Your Honor, and Your Honor just said the word that I believe is very important, that is specialties. And so when looking at what the courts have done, for instance, the 2nd District in Mann and Jackson, the 3rd District probably more recently in Tomas, the 4th District we contend in Rafferty, that appears to be a very important dividing line, even though no court has actually issued a bright line rule. It seems to be by specialty, or as Tomas said, cause of action. That's how Tomas identified it, as this is a different cause of action, this credentialing claim, which has its own corroboration and pre-suit, and therefore is something that needs to be specifically identified. the Jackman case too, and I know it's been quashed, but I do believe it's at least instructive here because it's what the second district was thinking. That court also did it by specialty. And that's the reason why that's so important is because section 766203, which is again the section that seems to be at issue here, says that corroboration needs to be by a qualified expert. And so that's what the court, the first thing to look at is, was the expert qualified to corroborate a claim? So here we have an OBGYN in pre-suit. And plaintiff's position is once that OBGYN says the OBGYN defendant was negligent, that's it as far as a medical facility, like a hospital, a medical facility here. That's all you need to do. You get a nurse to say there's nursing negligence. You can then sue that hospital for administrative negligence, a radiologist, neurosurgery, if it's vicarious, anything under the sun. And our position is that's not what Davis says. That's not what Davis held. And I think what plaintiff wants to do is take the holding of Davis, even though the underlying statutes are much, much different now, and use the holding instead of the rule of law. And it's the same with the Columbia case, Columbia versus Brown, which the 4th District followed back then. Now, Columbia versus Brown said once you sue a hospital, you don't have to also corroborate and pre-suit this negligent credentialing claim. Well, there's been a very extensive change in the statutes since Columbia versus Brown came out. That was, I think, a 2001 case. In 2003, the legislature, whether they were responding to that or just another case or not at all, but they changed section 766103 to add a requirement, 2 requirements. You've got to separately corroborate the negligence of nurses or support staff, because we have that here, anyone who's a support staff, and a negligent credentialing / privileges case has to be separately corroborated. And so that is why when plaintiff says that we're asking the court, that the lower court to not follow this court's precedent, that's not true. We are not asking the court not to follow Davis. We're asking the court to follow the statutes. And I think I can corroborate what I'm saying by pointing to decisions that have come out since the statutes have changed, such as the Jackman case. Again, I recognize it's quashed, but Tomas. And these cases recognize those changes, and I point out that I think 2 of the courts, the 2nd District, it may have been in Jackman, and the Tomas case, which plaintiff recognizes more recently, cited Davis with approval. Not one court has come out and said, we think this conflicts with the Davis decision. And so we either believe plaintiff's argument that they just missed it, got it wrong, and they say Tomas, they just accidentally or maybe purposely didn't listen to their own and follow their own precedent in the 3rd District, or perhaps the more parsimonious way of looking at this is none of them thought they were taking any issue with the Davis case, because Davis just stands for the proposition that not every theory of negligence has to be corroborated in pre-suit. So that's what we would submit.
And counsel, so there's sort of 2 issues going on. Are we looking at this on cert, or are we looking at under the non-final rule?
So
Does it matter?
I don't think it matters, Your Honor. And I mean, we just happen to be in a situation where I think either way, depending, because there's only 2 ways the court could have ruled. And one gets us into appellate. And that is, she found this expert to be qualified when that's not even in the affidavit, and I don't even think plaintiffs take that position. The only other thing she could have based her ruling on was the argument made at the hearing. And that is, you don't have to corroborate it. And so that's where I think it makes it easy for this court, because it is this clean legal issue, and we're not asking the court to reweigh anything the court did below. That's why I brought up, and we cited as supplemental authority, the recent decision from the 4th District. It just came out, Poparic, where the 4th District granted cert because an affidavit was filed, but it didn't match up with the allegations in the complaint. And again, There's no, conflict concern. The court was not concerned about conflicting with its decision in Columbia versus Brown. It just said, we have certiorari here. It was very careful to say we're not reweighing anything. And that's why I think here, if I had to just go by what the record looks like, for the reasons I said earlier, I think it's probably certiorari but we're guessing as to what the court did, but there's only two things, and either gets us there. So that would be.
If Judge Norton viewed it as the latter argument of corroboration not required, that leads us to cert. Do you agree with that?
Yes, Your Honor.
If it is cert, does it change our analysis?
I think, so it obviously changes the standard as far as a departure from the essential requirements of law versus de novo review. Was it wrong? Since there's such similar standards of review, I mean, we're still asking this court to analyze a legal issue. So for practical purposes, I don't think it changes anything here. Now, what plaintiff is saying, because when we filed Tomas, plaintiff came out and said, well, but you can't have cert if you're asking the court not to apply, the trial court not to apply binding authority. And our point is, it's not binding authority as far as supporting the legal argument the plaintiff's making.
And your view is it's not binding because the statute changed?
Well, it's binding. The rule of law is binding. The rule of law is binding. The holding is not binding because the statute has changed. And when I say statute, I say 766.102, which has changed considerably and is incorporated expressly into 766.203. That's why the holding's different, but I think plaintiff is conflating holding with rule of law. And we took no position below, and we take no position here that the rule of law has changed. And that is that you don't, as a plaintiff, have to corroborate every single theory of negligence. Every court's agreed with that. That is still the law of Florida, and this court does not have to take issue with that. So for these purposes, I do think it's probably one of those situations where it may not matter if it's certiorari or appeal. And again, if the court did what probably makes more sense, and that is found the expert originally to be unqualified because she dismissed the claims, but then agreed with plaintiff that they don't have to be qualified or corroborate anything, and I think it's certiorari because the appellate rule doesn't seem to really come into play there. Then we have just the clean legal departure from the essential requirements of law. The essential requirements of law are statutes. We have now 3 different district courts with their appellate decisions. We would submit and ask the court. It's a very important issue, and this is something that plaintiffs are litigating a lot and trying to, I think, expand on Davis. And this is the perfect court to bring this before. I would ask that this court apply the statutes, follow the courts that have been following this court, and quash the decision holding that plaintiff does not have to corroborate all of their separate claims in this case. And I will reserve whatever's left. Unless your honors have additional questions, I will reserve the rest of my time. Thank you, your honors.
All right, thank you. Mr. Rockenbach, is that correct?
Mr. Richardson.
Mr. Richardson, I'm sorry, Adam Richardson.
It's all right.
You may proceed.
Good morning. I, of course, am Adam Richardson, and I'm representing the appellees or possibly the respondents, depending on how the court decides on jurisdiction. So the first thing I want to note is that the appellants have radically changed their argument from their briefs to oral argument. They say now that we don't have to corroborate every theory of negligence. However, in their briefs, they said that we had to corroborate each discrete theory. And I agree with what they've said in oral argument. We do not have to corroborate every discrete theory of negligence. And appellants have focused a lot on the case law in the oral argument. I actually want to bring us back to the statutes, because the statutes are what control, as Ms. Sines said at the end of her presentation, talking about clearly established law.
Before we dive into the statutes, can I just ask, the theory of negligence, is is that looking at, within the same specialty, there can be multiple things that potentially occurred? Is that a theory? Are those the theories of negligence you're talking about, or are you talking about nursing versus surgeon versus administrative issues? It doesn't matter once you're in suit, even if you only had a pre-suit notice for, let's say, a surgeon.
Yes, that's our position based on the statutes. And the statutes operate at a higher level than what the appellants urge. So the appellants, as I said in the briefing, it was every discrete theory of negligence. But the statutes operate at a claim level where they just want corroboration that there are reasonable grounds for litigation. So if you look at, for example, the actual corroboration requirement, 766-2032, in that one paragraph, it says corroboration of reasonable grounds to initiate medical negligence litigation. Now that's not theories, that's not different kinds of claims if you want to say that there are legal differences between negligence, medical negligence, and something like administrative negligence, like negligent credentialing. That's just litigation. I don't think it's disputed that we've done that. We provided Dr. Del Carmen's affidavit. In the affidavit, we pre-suited both the doctor's negligence, and we said that he was in the course and scope of his employment, something like that. So we also pre-suited vicarious liability, that is a claim against the North Florida OBGYN. Right? So we pre-suited against both. Now in pre-suit, we're saying that we have another different theory against the facility, North Florida OBGYN. And it's at that, we think that is permissible under the statutes because it talks in mostly the singular rather than in the plural. So for example, we focused in the briefing not mostly on medical negligence litigation, but lower in that same paragraph to support the claim of medical negligence. And that's something—
Mr. Richardson, as a follow-up to Judge Kilbane's question, so you used the word when you initially began your presentation, discrete theory of negligence. And to me, that seems like a pretty ambiguous term when you're talking about, I believe the affidavit only targets or specifically mentions Dr. Wells, is that correct?
Well, as I said, it does say Dr. Wells, but then we also included in the affidavit expressly the vicarious liability of the center.
Okay, so if I take your argument through to its logical conclusion, then if you're able to carry on a suit against the center, even though you're focusing specifically on the care provided by Dr. Wells, that liability goes all the way down the ladder, and I'm not trying to demean any of the participants in the care, but literally you could go down to a nurse that changed the bedpan for the patient one time, correct?
Yes, but that's what the statute says. That's what it says. It says medical negligence litigation. It says claim of medical negligence, and it defines medical negligence in 766-2027 as what we understand it to be, medical malpractice, whether grounded in tort or in contract. And here I want to just point out what we recognize.
Even if there was no causation with regard to any of those disciplines that provided, a minuscule amount of care to the patient, you're still able to maintain a negligent suit against those individual participants in the care, correct?
Bring, but perhaps not maintain, because then they'd be able to get out on summary judgment. But I don't think that we're talking about bringing a lawsuit or a claim against like a party defendant nurse. It would still be against the facility. So the facility would still be on the hook as to other claims, and it would then be able to move later on summary judgment for partial summary judgment on those other theories, those smaller theories, if, as it happens, there's no causation.
So what is a discrete theory of negligence? What is your definition of a discrete theory of negligence?
Well, I think that we look toward what they kind of implied in the briefing, the appellants, which is every discrete act or omission that you could claim in the lawsuit. So I think what they would want and what defendants have been pushing in the lower courts on this issue is a very granular level, which is not how the statute operates. It operates at a higher claim level. And I've already pointed to the the actual statutory language, which supports us. But I also want to talk about jurisdiction or a standard of review, because that kind of gets into, I think, what the narrowness of the court's inquiry. So first, of course, we have the Florida Rule of Appellate Procedure that was amended in 2023 to allow interlocutory, which is, I think, plenary review of orders denying motions based on the expert qualifications, and it points to the specific statutes. I think they want to frame it, they need to frame it as involving corroborating this case, expert qualification rather than corroborating because of this court's decision in Davis. But if you look at the actual substance of their arguments, they're saying that a specific theory of negligence was not corroborated by Dr. Del Carmen. That takes us out of the rule and into certiorari. Obviously, this court, under another rule, has to consider that as a cert petition. And then the question becomes not whether there's plenary review, but whether there's a departure from the essential requirements of the law, which has been further defined in the case law as clearly established law. Now, at the time that the court ruled in our case, the clearly established law was Davis. Also Brown, because that's binding on the lower court in the absence of conflict. And none of the other district courts, in the opinions that opposing counsel has cited, have actually addressed this head on. They don't go, we disagree with Davis, we disagree with Brown, or even we disagree with Michael, which is a third district decision that followed the statutory amendments that my friend on the other side is relying on, but still reached the same kind of interpretation as Davis and Brown. And so
counsel,
yes.
Isn't their argument though, at least at some point, that yes, it wasn't corroborated, but also that it couldn't be corroborated by this doctor? Isn't that correct?
Yes, that's correct. But then you have still the distinction between the expert qualification and corroboration.
Right, but that's the issue, right? Because the non-final rule speaks to qualifications, and then there's the cert issue. So are we supposed to look at one under non-final and one under cert, even though it's the same issue? Because if they couldn't and they didn't, isn't that two different things?
No, Judge Kilbane. The reason I say that is because really you have to look at the substance of what they're saying. I understand they have to dress it up as a qualification issue to get under the rule. But what they're saying is, at the end of the day, our expert did not corroborate certain claims. You see that in the briefing too, because they can't get away from that framing. That's what their real argument is. And then you get totally outside of the rule, the amendment, and only into certiorari. And as I said, and as the Supreme Court reiterated in Carmody, the scope of review is a lot narrower. You're looking at whether essentially the circuit court faithfully followed binding precedent. And in this case, Judge Norton did. She followed Davis and Brown. And I think an interesting point to make about that is something that is based on a case that we cited in our SIR reply. It's a third district case called, State Farm Florida Insurance versus Sanders. It's from 2020. And there it's kind of an interesting procedural posture. So it was on cert, and initially I think the court granted certiorari. But then on rehearing, they denied it because they said that the scope and standard of review, and I'm paraphrasing here, I'm not going from the case, are significantly narrowed and forecloses the DCA's authority to address the continued vitality of its earlier precedent, even if subsequent developments in the law had undermined that. And this is true even if the precedent has been undermined by subsequent developments and was no longer viable. So there they said, but our hands are tied because the circuit court followed our binding precedent. And I recognize that's a third district case, not a case of this court, but I think that is the right analysis. It's consistent with the standard of review that we're looking at whether the trial court followed clearly established law or not. And again, our argument is that she did, which is Davis and Brown. Now, that's all certiorari. But I think what I was talking about earlier before getting to that, which is just looking at the statutes themselves and the interpretation, means that even if the court considered it on interlocutory review, which is plenary, we get to the same result. Because at that high level, the claim level, the statutes do not talk about different kinds of claims. They just say the claim or medical negligence litigation.
What are different claimants? Is there a distinction in your mind between claims and claimants? I'm sorry, between claims and those against whom the claim is presented?
Absolutely not, and the case law is very clear on that. The case law says that each defendant, the claim against them has to be pre-suited and corroborated. I think that's the basis on which the Third District held in Largy versus, I think, Gregorian, that a certain nurse who was not mentioned in the affidavit could not be subject to the medical malpractice case. And there are other cases like that too, where the defendant's simply not mentioned. Again, as the Dr. Del Carmen affidavit, and I'm sorry if I'm speaking a little quickly, I hope I'm not speaking too quickly. Okay. The Dr. Del Carmen affidavit mentioned both the doctor and the facility, his employer. So, I'm sorry, so that's a different issue. Those are not the cases that I think this falls within. And I think what the appellants want to do is kind of force it there. The cases like Largy and Mann, where there was a total failure to corroborate a claim against a particular defendant. Here, as I said, we've corroborated a claim against both the doctor and the facility. So even under appellate review, looking at the statutes, we believe that we should prevail.
What about the statutes that talk about specialty in the corroboration context? And I don't have the statutes in front of me, I apologize. But what about that? Does that have any impact on whether or not this constitutes corroboration?
No, I don't think it does. And the reason for that is, I do have the statutes in front of me, sort of. Yes. So, although in 7662032, they say, the legislature said, verified written medical expert opinion from a medical expert as defined in section 7662026. That doesn't necessarily sweep in all of the other stuff from 102. There's no dispute here that our expert, Dr. Del Carmen, was qualified to corroborate a claim against these defendants. So I don't think that then we have to get into, are they the same specialty or not? Because at bottom, we have a qualified expert giving us a corroborating affidavit against these defendants. There was something else I wanted to mention. Oh, the statutory amendments. All right. So Davis came out in the 90s and Brown came out, I think, 2001. And they're relying on amendments from 2003 and 2004. What I think is important about that is, although they made changes to 766-102, the legislature did not make any changes at all to 766-2032. And we have a very long-established canon of construction in this state, reiterated recently, of course, the prior construction rule. And that's if the court has given a construction to a statute and the legislature has done nothing or made changes to the statute without repudiating the case law, we take it as an authoritative interpretation. So we think that Davis, even after the amendments to 766-102, the amendments don't affect it because the legislature effectively adopted Davis and Brown. And I think what another important point about the amendments is that, I'm sure we all remember this, 2003 was major tort reform. It was a very significant revision of Chapter 766. And although they made many different substantive changes to Chapter 766 and specifically 766-102, again, they made no changes, substantive changes to the corroboration requirement. If the legislature had wanted to do that, it could have. We know that. It could have said in the corroboration requirement that we need to corroborate each act or omission, each claim. Didn't do that. And based on the supremacy of the text principle, we just look at what the statute says. It says what it means. We don't go beyond that. We don't make guesses. We take our cue from the legislature. We also don't expand on what the legislature did. And I think that what the appellants are asking the court to do is to put a gloss on the statutes that expands it, that inserts words in it that aren't there. And we believe that would be improper under statutory interpretation, and sometimes it's framed as separation of powers issues. Rewriting a statute encroaches on the legislature's authority to set policy for the state, which it did in the cooperation requirement. So I think, I know I have a few minutes left, but I think I covered everything I want to. Well, except for one thing. Okay, sorry about that. So Thomas involved administrative negligence. And I think the court got it wrong there. The court didn't carefully examine the statutes. And I think if it had, it would have reached a different decision. So in 766-203-2, which is the corroboration requirement, it speaks of medical negligence twice, medical negligence litigation, and the claim of medical negligence. And then in 766-2027, which I've already referred to, the legislature defined medical negligence as medical malpractice whether grounded in tort or in contract. And Thomas purported to recognize the distinction between medical negligence claims and administrative claims like negligent credentialing, non-clinical stuff. But we know that the statute the legislature drew a distinction between the two. And that's in 766-1027, which is one of the statutes the appellants rely on. So clearly the legislature recognized the distinction between these two types of claims, but it limited corroboration only to medical negligence. So our position also, in addition to all the other many arguments I've made, is that the legislature does not even require corroboration of an administrative negligence claim like this, because expressly it's limited to medical negligence. And I think if the court is really going to just follow the statutes, it would have to reach that holding. And I realize that would be in conflict with Thomas, but if the court disagrees, it disagrees with Thomas. And for all those reasons, we ask that the court find that this is not subject to appellate review under the amended rule. It is instead cert, and that under the narrow standard of review that this court has, that we should prevail for different reasons, either because the lower court relied on binding case law from this district and other districts, or because if you're going to go straight to the statute, we've still done our job. We corroborated the claim. If the court doesn't have any further questions, that's it for me. Thank you so much.
Thank you. Stein, you have about seven minutes and 42 seconds.
Thank you, Your Honor, and I don't expect to take them all, but I will address some points counsel made and some questions asked. And I'll start with the question that is, what about the same specialty requirements? Should we look at that context? And just to make something clear, the same specialty requirement was legislated after these older decisions. I believe that was 2013. And we're also relying on those changes as well, which were extensive. And Tomas really brought that to a head and said, well, if we take plaintiff's argument that you don't have to separately corroborate those, and in that case they had a qualified, apparently, expert. He just didn't explain why there was privileging and credentialing negligence. And it said, if we don't enforce this provision, subsection 7, then it's just a useless provision because you're always going to have an expert who can say something against the hospital and you won't have to corroborate those claims. I will also remind the court that Tomas cited Rell versus McKella, which then cited to Davis. It specifically cited to the Davis decision with approval. So again, either plaintiff is saying that Davis Tomas not only got it wrong and just missed the boat, but they also found that it was agreeing with this court. What plaintiff says that to subsection 766-203 hasn't changed, this is what it says. Corroboration of reasonable grounds to initiate medical negligence litigation shall be provided by the claimant's submission of a verified written medical expert opinion from a medical expert as defined in section 766.2026, which of course incorporates the extensive amendments that have been made over the years in the tort reform to section 766.102. And as far as, again, I'm not sure I need to say this again if I did already, but this concept of the Sanders case and this continuing vitality of binding precedent, I don't think we've been inconsistent at all. I think we've always taken the position, and certainly trial counsel said this in the trial court, we don't take issue with Davis's rule of law. It's the holding that just no longer, to the extent it conflicts with the statutes, no longer applies. I understand that plaintiff wants this to be unreviewable. I disagree entirely. I think just depending on what the court did, there are two very robust areas of review for this court, and that it has jurisdiction. And again, I submit it's an important issue. I do think it's an important issue for this court's consideration, and I would submit that the court accept jurisdiction. So thank you for your Honor's time on this petition, and if your Honor's, yes, Your Honor.
Sorry.
Yes.
And I was just curious, do you agree with Mr. Richardson that it's undisputed that their doctor was qualified to corroborate the claims?
Absolutely not.
Did not?
Absolutely not.
Okay.
Yeah, and they didn't take, and I'll just point that out as far as the record, because I did go back over that just in preparing. They didn't take that position in the second round of the motion to dismiss. In other words, they didn't come to the hearing and said, yes, he's qualified. They didn't even say it in their written response. And I think the reason is because this is an out-of-state expert, so she cannot corroborate nursing claims. And she's just an OBG, not to say that just an OBGYN, she's an OBGYN. So it could be an office practice, and she said nothing about working in either a hospital or some kind of a practice where she'd know about this concept of administrative non-clinical claims. So without that, it was our position and still is that she is not qualified, because they had every opportunity to bring in a different, maybe just argue, yes, she's qualified, she just didn't mention it, but they never did. And based on her affidavit alone and her attestations, she never showed her qualification despite 3 hearings on this. So we disagree with that and say she's not qualified for any of it because they failed to show it. Thank you, Your Honors.
Thank you. Thank you, counsel. Now, let's start with the appellant. Ms. Stein, if you would please turn around and introduce